Welcome, 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 everybody. Welcome to those who are just rolling in. We are also putting this live out in the world so that other folks can also get information, even if they can't catch us right now in real time. Everybody. Sorry about that. That's the live being live. So let's see. I'm going to give you all a little bit of time to kind of come on in, and we will get started in about 2 minutes. So grab you some water, make sure you're all set, and we will start in just a minute. Welcome, welcome. Thank you for being here on a Monday night as the year rolls to a close. And for those of you watching this in the future, thank you for taking time to watch. We hope you learn a lot. Those of you who are here in real time, we would love to know a little more about who is here and what you're bringing. So if you could drop in the chat, your name, your pronoun, where you practice, or where you are coming to this work from, that would be really dope because we can kind of find out who's in the room and just know a little bit more about our audience. That would be really fly. Welcome, welcome. We know that y'all come with a rich amount of information, rich engagement, desire. So definitely want to know who's in the room. You're just jumping in. We're curious to know where you're coming to this information from, if it's a law firm that you're at, or if you're just an interested party, if you have a friend who has a charge and you want to get more information about supporting them. We would love, love, love to know. Drop that name, drop that pronoun, drop what you're hoping to get from tonight or where you're coming to us from in terms of your work or your interest. I think while folks are doing that, Martin, if you want to introduce yourself, and I think now is a great time for that, and I will do a short introduction of like 10 days before Martin starts his presentation.
So, good evening, everyone. As Jay just mentioned, I really appreciate everyone's time, especially considering it's a Monday evening. So thank you for sharing your Monday evening with us and receiving some of the information that we're going to be giving today. And Jay also asked me to introduce myself, not just show my appreciation. So my name is Martin Hutchins, Martin Hutchins Jr. I am a staff attorney and racial justice fellow with our city defenders. I'm sure this is going to be correct, so I'll just throw it out there. I am with our city defenders, one of your favorite St. Louis not-for-profit organizations, and that's the part I was being certain about. So again, I'm a staff attorney with our city defenders, and again, super elated to be here with you all.
Thank you so much, Martin. So just to introduce myself, for those who I might not know in the room, my name is Jay Marie Hill. I'm the trans justice organizer for the ACLU of Missouri. And we're super grateful to have you all here. Very excited to dig in, curious to hear from you all throughout the presentation. To couch where we are right now, many of you probably know, but in case you need a little more information about it, we are in the midst of a campaign called 10 Days of Trans Demands. And it is a super exciting time. This is the third year in a row that we've done it, and it's been a really phenomenal kind of response here. So really grateful to everybody who's been supporting our events. This is one of several events that we have offered this 10-day span. And we just want to really situate this as, we put out a report that shows people kind of how to be well-versed in talking about sex work and talking about what people might know as prostitution, but really that's kind of a pretty loaded term, right? It kind of almost immediately situates it in the criminal sense of the work of sex work. So we want to not only give people more nuance to talk about this work and talk about the types of struggles folks are holding and living through, but we also want to really shift people's attention towards the recommendations that we offered in the report, one of which is to treat sex work like work. The second is to expand kind of our attention to health policy, so that it can include sex workers, which would by almost essentially default include trans folks, not because all trans folks do sex work, but because both populations and the overlap of them exist in a sort of underclass, both in Missouri and in society broadly. So To push back against that, our third recommendation is for people to, really push back against the law enforcement harassment that sex workers experience, and also many trans folks too, whether they are sex workers or not. And by doing those three recommendations, we will also be fundamentally shifting the attention and the energy towards, investing in community and giving people more tools to get out from under the thumb of criminalization and out from under the thumb of when society spends so much time criminalizing folks and not actually giving them the resources they need to survive. So we know that many people have been caught in the web of criminalization, and want to make sure that as people recognize that there are other ways to treat sex workers or treat folks who have needed to do sex work in the midst of their survival efforts, we want to make sure that people know that they can actually get things off of their records when very specific items and information are compiled. So really excited to hear from you, Martin. Thank you so much. Please let me know if you all have any questions. You can put them in the chat, or we can, you can put them out loud. We're going to stop throughout to give you time to ask them. And otherwise, here to listen and learn from you, Martin, and then we'll plug, the report in 10 days again at the very end. So thank you all for being here. Can't wait to hear from you. Excited to have you here. Martin, go ahead and take it away. I wonder if you are on mute, but yes, take it away.
You're correct. I was on mute. So as Jay just mentioned, if you have any questions at any point during the presentation, please use the chat window, or towards the end, if we have time, I'll open the floor for verbal questions. And I will make my best effort to address as many questions as possible. So again, thank you for your time to discuss expungement. As my very first slide indicates, this is an information session. So with that being said, one of the primary goals here is just to arm more people with information relating to expungement. Whether you're a person who yourself could possibly benefit from pursuing expungement, or if you're a person that works with the population to share this information, or just an individual that want to share information, whatever your reason may be, we appreciate it. So generally, the word expunge it means to erase or destroy. So to give you all a little bit of context, in Missouri, expungement does not actually result in a record being totally erased. It's sealed. And so I've already see a point in which I need to step back a little bit. And so we're talking about criminal records here. And those records relate to incidents that actually involve a person being convicted, meaning they were actually found guilty at the end of a trial or entered a guilty plea. But it also includes records that relates to offenses only relating to arrest. So for example, a person was pulled over, received a ticket, but charges were never pressed. So there was never a need to go to court. That's an arrest record that does not relate to, again, a conviction. But that's also a record that a person may want to have expunged. It could be something that shows up on a background check. So again, expungement does not only relate to offenses in which a person was actually convicted. So again, the word expunge itself means to erase or destroy. And in the United States, there are various expungement laws for every state and federally. So our focus tonight will only be on Missouri. And so again, in Missouri, once a person is successfully granted expungement, their record is not completely destroyed. It's sealed, which means that the record is made really confidential, and there are only a few exceptions in which that person's criminal record can be accessed, which we'll talk about that a little more as our presentation goes on. In Missouri, The primary expungement law and the main law that we're going to focus on today is 610.140. And this law underwent some major changes back in January 2018. So considering those major changes that just occurred in January 2018, and the fact that there are so few people that are actually applying for expungement in Missouri, these reasons are reasoning to come to the community and just make sure you all are as informed as possible about the expungement. Again, the law just underwent some major changes, and not that many people are utilizing this law for their benefit. And just very broadly, some of those major changes that came about in January of 2018 include a shortened waiting period. So before 2018, a person with a felony offense on their record had to wait 10 years. Now the waiting period is 7 years. Still a pretty lengthy waiting period, but it's a step in the right direction. Another example of a major change that came about in January 2018 includes the number of offenses that are eligible for expungement. So as of right now, there are only about 85 offenses in Missouri that a person cannot seek expungement for. Before 2018, that list was much, much longer. So that means that there are now far more people that can pursue expungement without their offense being totally ineligible. And as I mentioned earlier, there just aren't that many people that are applying for expungement. And there's an annual report that the Missouri courts releases every year. And back in 2018, their report indicated only about 1,100 people applied for expungement across the entire state of Missouri, only 1,200. And of that 1,200, only about 378 were filed in the greater St. Louis area, and only about 62 were filed in the greater Kansas City area. Again, there should be far more people applying for expungement. Those numbers are just so low. But with most laws, most people just don't know what rights they have or just the proper starting point, which is one of the reasons we're here tonight. And so one of the benefits with expungement, again, that record being sealed, is just going to open up a few more opportunities for people and remove some of those hardships that are caused by a criminal record. For example, the barrier that's caused with finding housing or finding employment. These are some of the benefits that expungement can help a person once granted. Again, more housing opportunities, more employment opportunities. So again, the primary law that we're going to focus on today is law 610.140. And in a person seeking expungement, there are going to be 5 requirements that must be met. And so before we dive into the specifics of these requirements, again, in this information session, this is just really meant to get everyone's mind going to consider if they self may be a person that should start considering expungement or just a person to spread the word. But I want to make sure that tonight's information isn't construed as legal advice. I'm going to say this throughout the entire presentation, but it's always great to work with an attorney. And I recognize getting legal representation isn't the easiest thing, nor the cheapest thing. So I fully recognize the amount of privilege in that statement. But when possible, this process is a process that should be tackled with an attorney. And so as we're going through these requirements, I really aim for people to just begin the thought process of is just a process that they themselves should consider. So for the first eligibility requirement, the court is going to ask, is the offense eligible for expungement? And so again, expungement is going to be the legal process in which a person's submits an application with the court that the offense occurred, to ask the court to seal that record. So for example, if a person was convicted of trespass in St. Louis City, then the St. Louis City court is going to be the proper court to apply for expungement. And so in reviewing this criteria, this is only going to focus on the violation itself. So just for this requirement, we're going to focus on the law that was violated instead of the person that violated the law. So as we discussed the eligibility of the offense itself, there are two broad ways to think about it. The expungement law gives a section that lists approximately 85 laws that are just ineligible for expungement. And this chart that we have right here are just a few examples that comes from the expungement law section that explicitly lists those laws that are ineligible. So if a person is convicted of arson or even arrested for arson in the second degree, this violation is explicitly listed in the expungement law, therefore it's ineligible. So that means a person with any of these records cannot have that record itself expunged. And so the distinction of the point that I'm trying to clarify here is, if a person has a perjury charge and a trespassing charge, that person can still seek expungement for their trespassing charge, but not perjury, because again, perjury is flat out ineligible because it's listed in the expungement statute. And again, that only applies to the offense. And so here I have arson in the second degree, forgery, identity theft, mortgage fraud, etc. Everything else that's listed on the screen. So I won't read the entire list. And this is only a few of those offenses. And towards the end of the presentation, I will show a link that takes you directly to the expungement law to see that full section of excluded laws that may not be expunged. And so other than the laws that are explicitly listed by the expungement law as being ineligible, there are a few broad categories in which if a person's offense fits into these broader categories, they are also ineligible. So again, I won't read the entire list that is displayed here, but starting off with number one, Class A felony. Any offense that's a Class A felony is a category that's just flat out ineligible. Any dangerous felony, which generally includes arson, rape, sodomy, kidnapping, assault against a special victim, etc. Those are dangerous felonies. Offenses requiring registration as a sex offender, so another category that's totally ineligible. So again, in determining or trying to determine if an offense is ineligible, that's only going to occur if that law is explicitly listed by the expungement law, or if the person's offense falls into any of the listed categories. So with that, I'm going to pause to see if there has been any questions, because the evaluation of the offense itself can be a little tricky. Jay, have you noticed any questions?
I don't have any questions in the chat right now. And I think the only thing I would want to offer is that, even though the expungement law just underwent new, upgrades and changes in the last couple of years, I think at the ACLU, we're also very curious about, the the positionality of sex workers and what they're charged with being in this category of ineligibility, right? So we want to really draw that line clearly so that essentially sex workers aren't caught up in the sex offender registry, for example, right? But there's just like a lot of nuance there that we'll definitely get into in the future, but right now don't have any kind of clear specifics to add or like action items. But I just wanted to name that like this is kind of exactly the place that we want to dig into, you know what I mean, in the coming months and weeks, because we know that there's like a lot of conflation there. So yeah.
Yes, which brings to a great point, especially the category of offenses that require registration on the sex offender registry. Again, as I mentioned earlier, this is a process that at some point a person should work with an attorney. So if there's ever any question of am I on the registry or should I have been on the registry because I committed whatever offense, that's something that your attorney can help you determine. So again, this just gets you thinking about your own or another person's eligibility, just to get the process of expungement in your mind.
Right.
So it eventually leads you to an attorney.
We have a comment in the chat real quick. Sorry, apologies that we didn't make this more plain initially, but I'll actually just go ahead and read the definition from the report that we just published. And I encourage everybody, I'll put the link in the chat as soon as I'm done reading this definition. The website is just mohojustice.com because we are a coalition of folks working to bring more justice to hoes, aka people who do sex work or people who might be thought of as people who don't deserve justice. So just to read the definition from our report, sex work denotes consensual adult participation in the commercial sex industry, including but not limited to porn, stripping, camming, selling in-person sex acts, erotic or tantric massage, escorting, and professional kink or BDSM services. Sex work also includes folks who trade sexual services for housing, drugs, medical care, transportation, or other valuable goods and services on an as-needed basis, but do not necessarily claim the title sex worker or erotic labor as their profession. So definitely hope that clears up the question for folks. That was a great question, not a simple question. It really is a changing of the tide in terms of wanting people to know who is in this new kind of bucket that is often overlooked or that people don't have the tools to know who fits in there. So great question, and I'll toss it back to you, Martin.
Thank you. And another point to bring up, although the expungement law that we're currently focusing on went about its major changes in January of 2018, since that point, the law has been amended a couple of times in very meaningful ways. So in January of 2018, the offense of stealing was one of those charges that was flat out ineligible. But since that point, there has been changes to the law, and stealing is now eligible. So that means that law was taken or removed from the ineligible list. So people with records relating to stealing, whether it's just an arrest or a conviction, are now eligible for expungement, which just gives an insight of more changes that can happen with the expungement law, whether it's removing one of those broader categories or removing one of those listed laws.
And there's one more question in the chat. I think we can offer now, which is for the offenses that you are ineligible for an expungement for, does that include arrest even if there was no conviction?
Excellent question, and thank you for making that distinction. So, unfortunately, which is another point of Missouri's law that needs to be changed, it doesn't matter if there was a conviction or just an arrest. So even if it's just an arrest that charges were never brought or charges were unsuccessful, if it relates to a law that's listed as ineligible, a person may not seek expungement under the law that we're talking about today. And the following slide are just a few more of those broader categories in which an offense can be categorically ineligible. We see number 8, some intoxication-related traffic, boating, and aircraft offenses. Number 9, ordinance violations that are the substantial equivalent of non-expungible offenses. So an example of this, trespassing. There's a way to be charged at the state level for trespass, but many municipalities, so think St. Anne, Bridgeton, Ferguson, receiving a ticket for one of those municipalities is going to be an ordinance violation. And a lot of those ordinances closely mirror state laws. So there's more than likely a trespassing ordinance for all of those municipalities. So if trespassing was ineligible, which it is not, so please pardon my not the best example right now. But if trespass was ineligible on the state level, that will also be ineligible as an ordinance violation, which is another point in which working with an attorney would be very helpful for. So after determining if a person's offense is eligible, the next requirement relates to time. And I briefly mentioned this earlier, and this is another point in which the current law is much better than the law was before 2018, because that time has shortened. So one, the time is going to vary depending on what level of offense a person is dealing with. So if it's a felony offense, that time period is going to be 7 years. And for everything that is not a felony, so misdemeanors, ordinance violations, infractions, that's going to require a 3-year waiting period. So the first requirement here, again, the waiting period. So in calculating the waiting period, the court requires a person to count backwards, which I want to go into a little more at the end of the slide. So let's say I, Martin, have a felony record, and I want to, of course, start thinking about expungement. I am not eligible until 7 years has passed from the completion of my disposition. And so disposition is your sentence. So if after being found guilty for my felony, if I was sentenced to do 500 hours of community service and do 3 years of supervision, court supervision, that means I have to wait until that 3 years for the supervision period is over. All of my community service has been completed, and all the money I've paid has been paid. All the money I've been required to pay has been paid before my count can start. So again, 7 years. It has to be 7 years beyond all of those requirements being finished. Again, that community service, all my fines paid, my supervision period being over. And so when I say count backwards, today is December 7th, 2020. So counting backwards will take me to December 7th, 2013. During that entire period, all of my sentence requirements must have been completed. If I didn't complete my community service until 2018, that puts me in violation of a 7-year period. So I'm gonna have to wait longer so that I can have a period of 7 years in which my community service was totally done, my money was paid, and all of my other sentence requirements were taken care of. And for misdemeanors and everything else that's not a felony, that period is 3 years. And so this period is also important for one more requirement, which I'm going to describe as the crime-free period. So again, if I'm a person seeking to have a felony record expunged, the court is going to look back 7 years. So again, going all the way back to December 7th of 2013. During that entire 7-year period, I must not have been found guilty or entered a guilty plea for any other misdemeanor or felony offenses. So again, the timing requirement relates to how long has it been since the person has completed everything that was ordered with their sentence, and it relates to, did this person avoid committing any other criminal offenses during that 7-year period or that 3-year period. So, please pardon me. A little more about the crime-free period. This generally will not include traffic violations. However, driving while revoked or driving while suspended will count against this crime-free period. So this is an exception in which traffic offenses can mess up a person's expungement eligibility. So again, going back to my example of me looking to file an application for expungement with a felony offense on my record, if last year I have a speeding ticket, that speeding ticket would not prevent me from receiving expungement. However, if I plead guilty to a ticket for driving while suspended 2 years ago, that will prevent me from getting an expungement during that period. So one final note to make about the waiting period. The great thing about the new expungement law is if a person messes up during this period, and for the sake of this conversation, when I say mess up, I mean there's some reason why they would not be eligible for expungement. Either it has been long enough since all their fines were paid, or they have committed another criminal offense. That clock can start over. So with me getting a driving while revoked ticket 3 years ago, that means if I file my petition for expungement today, I'm going to be ineligible. But if I just wait a few more years, that time is going to reset, and now I can achieve a 7-year period in which I don't have any more convictions, and which I can say it's been 7 years and my fines and fees have been paid for at least 7 years. Again, working with an attorney is going to be extremely helpful with determining if you have satisfied the timing requirements. So the next area of requirements that must be met for a person to be granted expungement is going to look to ensure that a person has satisfied all the obligations of their sentence, which we briefly mentioned previously with the timing requirements. And so the difference here is this is going to strictly focus on the offense that the person is looking to have expunged. So using myself as an example again, if I have a stealing offense on my record, and once I was convicted for stealing, if I was ordered to pay restitution for whatever I stole, that's a requirement that has to be fulfilled before I can be granted expungement. And so just to point out a minor difference from the timing requirements that I mentioned, here, if I have some obligation that has not been fulfilled for another charge, like a trespassing charge, but I'm looking to fulfill my stealing, or I'm looking to expunge my stealing charge, it's only the obligations that was ordered during my conviction for stealing that matters with this category.
Just want to offer one question that might have been answered, but I don't think so. The question is, what if you have a technical violation of probation or parole? Is that something that will interrupt your eligibility?
Great question. So, so the question asks, will a technical violation interfere with a person's seeking expungement? I'm going to say, and I'm sorry to do this to you, but I'm going to say yes and no. I want to say no because the violation itself won't prevent a person from receiving an expungement. But the yes part comes from if a person is still actively on probation, that means their disposition is not yet complete. Therefore, they are not eligible for expungement. So if a person is on probation and still currently on probation, then expungement is not, that they aren't eligible for expungement at that point. So again, the yes to that question came from the fact that that person is still actively on probation. If you're still actively on probation, you are not eligible.
Awesome, thank you. And y'all, please continue to ask these really great questions in the chat. We're about a little past a third, approaching halfway through.
So finally, the second bullet on my slide says, do you have any pending charges? So earlier I mentioned that a minor traffic violation would not stop a person from receiving or being granted an expungement. Do you have any pending charges presents a bit of a different issue. This asks, is there anything open that's currently pending? And so the law isn't quite clear here, which is going to be another reason why working with an attorney is extremely helpful. But that traffic violation, having something pending could absolutely prevent a person from being granted expungement. And of course, any other pending charges, whether it's a pending trespassing charge, a pending stealing charge. So effort into reviewing a person's record through CaseNet, MuniCourt.net will be extremely helpful to make the self-determination of, am I eligible for expungement? So this will lead you, hopefully, my goal is to inspire you to go and look out in the web, whether it's CaseNet or MuniCourt.net, which I'll show a little later, to do a quick name search to see if there are any pending charges, which is very common. We live in the city, St. Louis City, in which this comment is giving a strict focus to St. Louis County. But we live in an area in which you can drive 10 minutes down the street and hit 17 different municipalities, which I really wish I was exaggerating, but it's the honest truth. So I said to say it's very common for people to have pending charges, whether they're from 10 years ago or 10 months ago, just from the volume of municipalities that we have in St. Louis. So for any person that's considering expungement, doing a search to see if there are any pending tickets, whether old tickets or new tickets, traffic or non-traffic related, is always a great point, which working with an attorney will help you do. So the next area of requirements is the area that really allows the court to use some of their own discretion. And by discretion, I mean their personal judgment. And so the difference here is the requirements that we covered earlier, they're more clear cut. It either works in favor for the person or not. So for instance, the expungement law asks, are there any pending charges? That's either yes, there's pending charges, or no, there are pending charges. An earlier requirement that we covered asks, is the offense itself eligible? Again, the offense is either listed or fits into one of those categories, or it does not. So those are areas in which the court does not have discretion to use their own personal judgment to grant or deny expungement. Is more clear cut. But the area of requirements that we're now covering does allow that discretion, which again is the court's personal judgment. And so here, this requirement asks, will the court's discretion determine that overall you deserve to be granted expungement, which is my own summary of these requirements.
I'm going to offer that there's a question in the chat about, and I know we're kind of on the other side of some recent legislative work, but the question is there any legislative work happening to change these laws and make it easier for folks to get their records expunged? So like I said, there has been something in 2018, but I didn't know if Martin, and also Sarah, I know you're not maybe in the place to present per se, but just wanted to offer some space to speak to that if you have any context or background, Martin.
Yes, great question. And this is a point that I really want to hit on towards the end of our presentation. So I am going to table that question for now. But great question that I plan to address. So in going back to these requirements, the first requirement asks, does your habits and conduct demonstrate that you are not a threat to the public safety of the state? So again, this is the court, and when I say the court, I mean the judge. So this is the judge using their own personal judgment after reviewing the person's expungement application, reviewing their record, and just thinking about the full package that has been presented by this person seeking expungement. The judge is going to use their personal judgment to ask, does this person's habit and conduct demonstrate that they are not a threat to the public safety? The next requirement is the court asking, is the expungement consistent with the public welfare, and does the interests of justice warrant granting the expungement? And so these two things, again, are going to be a full picture evaluation being done by the judge, considering things like background, community support, where this person's working, schooling, a lot of factors that the court and the law believes would tell the court if this person deserves expungement. So again, the purpose of the session is just an information session. Please don't construe my giving this information as my endorsing or validating that this is a good law, especially this evaluation that happens here. But just for the sake of your own information, it's important to know that there are requirements that positions the judge to use their own personal judgment to determine if a person deserves expungement. And so information again about a person having excellent community support, whether it's a community rec center or a religious institution, or a person that's been working a job for 3 to 4 years, or a person that has been actively doing community service in the wake of the pandemic that we're going on, that's going on right now. Any information that can show that the person seeking expungement deserves to be granted expungement is going to be helpful here. Again, as I've been stating throughout the entire presentation, working with an attorney is going to be extremely valuable, especially for this category, because it's not as clear, this category is not clear cut as the earlier requirements that we have covered. Next, lifetime limits. Pardon me, my fingers are moving a little faster than I like. So with the current law, there are a few limitations on the number of expungements that may be granted. So as the slide indicates, a person may have 2 misdemeanor that has an authorized term of probation, an authorized term of imprisonment expunged. So this means if there's a misdemeanor that a person commits, and if there's a possibility that that person can be sentenced to jail, whether or not they actually are sentenced to jail, this is going to place them near this limitation. So if I have a Class A misdemeanor and a Class B misdemeanor on my record that happened 5 years apart, I can have both of those potentially expunged. However, after that point, I would not be able to apply to have any more misdemeanor offenses expunged unless it's a Class D, D as in dog, unless it's a class, perhaps a Class D misdemeanor, which does not have an authorized term of imprisonment. Right now, a person is only allowed to have one felony expunged. And again, for limitations, it's important to again remember that it does not matter whether it was just an arrest or an actual conviction. It only matters about the offense itself. So a person may only be granted one expungement for a felony. Now, there is an exception here, which again is another reason why working with an attorney is going to be extremely important. So one of those exceptions says if a person was charged with multiple offenses, but on one indictment, then those limitations can be bypassed. So for example, if I have 3 felony convictions, because I was charged with 3 felony counts on one indictment, so count 1 is one felony, count 2 is a different felony, count 3 is a totally different felony, but this is one indictment, I can now apply to have all 3 of those felonies expunged because they were all charged a part of the same indictment. Another exception, which requires a little bit more legal work, is if a person can show that multiple offenses was a part of the same course of criminal conduct, then all of those offenses are could possibly be expunged. So an example of that is there's a case that was litigated a few years ago in Missouri, in which this person had about 5 felony convictions for passing bad checks. And the court eventually granted this person expungement of 2 of those felony offenses. And it was shown that this person was cashing bad checks, a part of the same course of criminal conduct, because this person cashed a bad check at a convenience store in Bell Fountain, and then 2 days later, another bad check at a pharmacy in Moline, and then 5 days later, they passed another bad check in a different municipality. So this isn't exactly how the case went. This is just an example. But this is the same course of criminal conduct, and the court here said that it was the same act, meaning passing bad checks. They happen at different times and in different locations in different jurisdictions, but this person's doing the same thing, passing bad checks. So this is an example of the same course of criminal conduct. So this, again, is going to require building more of an argument, which is why using an attorney is going to be especially crucial there. But of course, it's a great idea to pursue expungement for as many criminal records that a person has as possible. So if it's a person that one of those exceptions can fit, again, work with an attorney so that you can be sure that you're getting the most bang for your expungement application as possible. And one other thing that's really important to point out, as the slide states with the bottom asterisk, for purposes here, full expungement allows a person to say that they have no criminal record. However, more often than not, people have multiple offenses that can be expunged. Deciding whether to seek expungement now or which offenses to expunge may be difficult because, again, there are certain limitations. And so, again, working with an attorney will be extremely helpful to make the best strategy determination to make sure expungement is going to be as effective for you as possible. So I believe I've seen a couple of questions pop up. Jay, do you have any more questions?
Sorry, I don't. I was actually just encouraging. You caught me right when I just put a bite of dinner in my mouth. But I was just encouraging folks to keep asking great questions. And I wanted to also check on just timeline if you had any updates on which, I'm not counting slides and I can't see your full screen to see which slide, but just wanted to encourage folks to like stay engaged, grateful for you. I think, sometimes when you're presenting or listening to a presentation, it can be a lot of information. So just it's helpful sometimes if you think you have a question and you're not sure about asking, please ask it because it actually helps us all learn together. So just really grateful for those questions we've already heard. And wanted to highlight that Sarah did offer in the chat more context about expungement legislation. So she wrote, there are several bills filed to expand expungement opportunities, and starting in January, we'll have a list up on our site, the ACLU website. Make sure to get that out to folks here. And right now, the legislature is engaged in pre-filing because session runs from January, formally begins in January, and it runs until May. At least that's the regular schedule. We know that COVID has impacted many things, so that's kind of the setup that we're expecting, though.
That's great. Thank you very much for that. And I actually meant to say this much earlier in the presentation, but with the topic of COVID being brought up by Jay, and of course we're dealing with it every day. This is just another example of why learning about and discussing expungement is especially crucial right now. As we are bouncing back from COVID-19, we've heard so many elected officials make comments about reopening society and figuring out how to do things differently and operate anew outside of COVID-19. And so taking advantage of expungement is going to be extremely, again, crucial for people. Criminal records just have such a harmful impact on people, with housing and finding a job, which are going to be things that people are actively doing now and will be continuing to do as we bounce back from COVID-19. And so positioning a person to not have to report their criminal record or just to continue to deal with those impacts of a criminal record makes learning about expungement so important, because these people are going to be greatly impacted by these various things, even more so after COVID-19. And please pardon my dogs. They're also excited about this information tonight. So something I especially wanted to share with the group tonight. There are a few other expungement laws in Missouri. There are a total of 5 expungement laws. And again, I focused on 610.140 because it's the newest law and the most expensive law. But one of those other expungement laws includes 610.131. Now, this expungement law is focused on individuals that have criminal records relating to prostitution charges. And so if there is a person that is eligible for expungement under this law, it's a great idea to be granted expungement under this law before using the previous law that we discussed, which again, working with an attorney is going to be really helpful here. And so I'm going to go back a little bit just to give a visual aid as to why this is extremely helpful. So earlier we talked about limitations on expungement. Under 610.14, again, you can only have 1 felony expunged or 2 misdemeanors expunged, but that's only under this law. So going back to 610.131, if a person can have a criminal record expunged under this law, that means those limitations of 1 felony and 2 misdemeanor offenses are irrelevant because that law is being used if 610.131 is a possibility. But this, again, only has very strict application. So 1, this law applies if at the time of the offense was committed, the person was either under the age of 18 or acting under coercion. And coercion is just going to be threats of serious harm to a person or physical restraint to a person, or any plan that was made for the purpose to cause a person to believe that they would be seriously harmed or physically restrained, or the abuse or threat of abuse of legal process, meaning the threat to be arrested, the threat to be sued for some sort of malicious or vindictive reason. Those are all coercive actions. So again, if a person was either under the age of 18 or committed some criminal act under coercion, and their conviction is a conviction for prostitution, then they can receive expungement under this law. So again, that's going to be beneficial to apply for expungements specifically under this law, because it's going to leave those limitations with 610.140 untouched. And some other benefits here: if a person qualifies for expungement strictly for a prostitution charge, again, being under the age of 18 or being a direct result of coercion, that waiting period that I talked about previously, that doesn't apply here. Having pending charges, again, that doesn't apply here, because this law does not have the same requirements as the primary expungement law that we focused on. And also, as number 3 says, habits and conduct. That evaluation of a person's habits and conduct that the judge makes under the other expungement law, that is irrelevant here, because this expungement law does not have the same requirements. So if there's a person that has a prostitution charge and they were either under the age of 18 or their act of prostitution was a direct result of coercion, they can seek expungement under this law. Again, I want to encourage you to reach out and find legal counsel to make the best determination of which expungement law works best for you, or what's the best way to tackle your criminal record in its entirety, using the various expungement laws that Missouri currently has. And I know that I'm throwing a lot of information at you all, information based on law, which laws are just, unfortunately, really confusing. So I'm going to reinforce what Jay has been doing throughout my presentation. If you have a question, please ask. These things are very confusing. So now going into discussion about the results of expungement. And so here, I mean, once a person is granted expungement, what's going to happen? So one, except as otherwise provided under the law, when it says this section, it means the law. The effect of an order for expungement shall be to restore that person to the status he or she occupied prior to arrest, pleas, trials, or convictions, as if such event never happens. So this is the court saying, if a person is granted expungement, the goal is to return them to the status that they had before that conviction or arrest was ever made. No person who has received an order for expungement shall be held guilty of perjury or otherwise for giving a false statement, for the failure to state or acknowledge such arrests, pleas, trials, or convictions. So that means a person cannot face charges of perjury or for giving a false statement otherwise if they answer no to ever being convicted or arrested if they are granted expungement. And again, that only strictly relates to whatever offense was actually expunged. So if I was granted an expungement for my stealing charge, I can answer no, have I ever been arrested, if that was the only thing on my record. But if I have other things on my record that were not yet expunged, then I still need to keep those things in mind. More about the results of expungement. So after an expungement has been granted, there are a few exceptions in which the person is still required to share information about their record. So for example, if a person is looking to get certain licenses, like a gaming license or some sort of license to open a daycare center, those are examples in which disclosure must occur relating to a criminal record. Now, earlier in the presentation, I made the distinction of an expunged record being sealed and not totally destroyed. And so the second bullet point really touches on that. So if a person, let's say they were successfully granted the expungement, let's say 5 years after that, they are convicted for another charge and they're being sentenced, the court and the prosecutor can consider that expunged record as part of that person's sentencing. And again, as I mentioned earlier, as bullet point number 3 says, disclosure is necessary to complete an application for certain licenses, permits, and employment. Again, anything dealing with gaming, like casinos, anything dealing with the healthcare, and generally children are going to be exceptions in which disclosure of the expunged record is necessary. Now, failing to disclose in that situation can result in perjury or other charges relating to giving a false statement. So again, in Missouri, once expungement is granted, that record is not totally destroyed, and there are still instances in which that record can be shared with third parties, or in which the person granted expungement must still reveal information about their record. So some issues that are really faced with the expungement process are covered right here with this slide. And one of the biggest really relates to the hardship in just gathering information. It's so very likely for people not to really know which law that they were convicted under, or to even determine if they have pending charges. So again, working with an attorney would be extremely helpful here. So in going and actually filling out the application for expungement, a person is required to list each offense that they want expunged. So again, getting that full criminal record is going to be really helpful so that you can make sure that you are seeking expungement for all the things on your record that's possible. The approximate date charged for each offense is going to be important. The case number and the jurisdiction in which the offense occurred. And again, working with an attorney is going to be helpful in getting all that information. Another issue that one must consider with expungement is sometimes it may be a good idea to wait to see how the law will evolve. So as I mentioned earlier, stealing once upon a time was ineligible, but is now eligible. And as we just mentioned, there are going to be more bills to come out to make changes to the law. So working with an attorney can be really helpful to determine if filing a petition or submitting your application for expungement now versus waiting a few years may be better, because there's a possibility an offense that is just flat out ineligible may become eligible as the law continues to change. So of course, applying for expungement earlier versus waiting will impact that limitation, because again, you can only have one felony expunged in your lifetime. So if I'm a person and I have multiple felonies on my record and I file for expungement because one of my 5 felonies are eligible and the other 4 are not, I just used my one felony expungement, versus if I would have waited 3 years and now the other 5 are also eligible, and I would then have the opportunity to pick and choose which felony I want to expunge. So again, it can be really frustrating and really really energy draining to have to be strategic to determine when to apply for expungement, or what record should I seek expungement. But again, that's why I'm really reiterating to work with an attorney where possible. Some other issues, there are, of course, with many aspects of the legal system, there are some financial implications. One, there's a minimum filing fee of $250 in Missouri to file the petition for expungement. Now that fee can vary across the different jurisdictions, whether it's St. Louis County, St. Louis City, Kansas City, Jeff City. That price can change, but it will be at least $250. Now there is a mechanism in which a person can ask the court to waive that fee. But one, again, working with an attorney is going to be really helpful here. Two, with most laws, most people just don't know about all the benefits that are out there. So I would not be surprised if a person has waited and tried to scrape together money to seek expungement, not even knowing that this fee can be waived. So one, I'm glad you all are here learning this, because now you know that fee can be waived, and you can tell others. But again, this price requirement is one of the issues with expungement. But even outside of the direct fee that the court requires for expungement, there are other financial implications here. For example, given that criminal record, there is a background check that the Missouri State Highway Patrol does that private individual people can do for themselves. But that background check costs about $28, nearly $30, which, again, considering we're now in the midst of a pandemic, $30 goes a long way for some families. So this limitation and not having that full record can be harmful. So again, it's important to keep in mind that there are financial implications with expungement. And so that not knowing a person's full criminal record can be extremely harmful. If you look at the second bullet and its sub-bullet, if there's a mistake made on a person's petition for expungement, or that petition is just determined to be ineligible, that individual may not seek expungement again until a year passes, which for some, a year may not sound very long, but for others, that's another year of that person's dealing with all the implications and harms that their criminal record has caused. So if there's a person looking for better quality housing, that's another year that they have to wait to be granted expungement, which means another year of having to report to the various apartments that they have whatever criminal record that they have to report. So, again, here comes that plug again. Working with an attorney is going to be one of the great ways to make sure an application is not being submitted where a person just is not eligible. It's a great idea to put forth as much energy and time to determine a person's eligibility before actually filing with the court. Because if a court tells a person that they are ineligible, then they have to wait another year. And that's another year of dealing with consequences they shouldn't even be still dealing with at that point. So right here, I have a few links, and I'm going to exit my presentation for a brief second just to show a few tools that a person can go to start doing their own personal evaluation if they themselves are eligible for expungement. And I'm going to zoom through these, and I am going to give another caveat that I know these sites that I'm showing, of course, require a computer and internet, which just aren't resources that everyone has. But even with that, some of these sites just give you a lot of information that just is not the easiest to really understand. And I fully recognize that. But with that being said, I still want to point these resources out in the event that a person wants to put forth effort to try to navigate them to determine their own eligibility. So one, CaseNet. So in going to the litigant name search, a person can search, I can search my name, and I can try to determine if I have any records or charges out there. Now, this does not mean that every single record out there will be shown on CaseNet, and it's even a higher possibility that the entire record won't be found by a person on CaseNet, but it's a starting point. MuniCourt.net is comparable to CaseNet, but this is only for records relating to municipal charges, St. Louis County municipal charges. So again, this is another tool that individuals can use to try to determine what's out there on their record, what pending charges they have. And when in doubt, if a person ever has the thought of maybe having a pending charge somewhere, I will encourage picking up a phone and calling the court to try to make that determination. But again, working with an attorney in this disciplinary process is going to be very helpful for that. And finally, which is going to be one of the most complicated and difficult tools I show, but this is a site that's provided by the state of Missouri that allows various laws to be found. There can be a person typing in the exact law number or typing in key terms to look for their various laws. So this is going to be helpful when we're trying to determine if an offense itself is eligible for expungement. So I'm going to go to the expungement law itself really quickly. Again, 610.140. In this section right here, these are all the laws that are ineligible because they are flat out listed as being ineligible. So if it's a person that may not know the statute number that they were convicted under, using the previous site or using this site would be a good way to identify the number that your offense correlates with. Again, a very complicated process, and another reason to work with an attorney, but there's that information. Finally, I am going to encourage everyone to go and sign up for our city's mailing list. Again, tonight's information is strictly for information purposes, but if you're a person that has a general need for legal assistance, visiting our website and filling out our client application is a great way to apply for our legal services. And I will also encourage you to apply for other legal organizations like Legal Services of Eastern Missouri, et cetera. However, I'm going to encourage you to sign up for our mailing list just to stay informed of some of the things and the work that our city is doing, including getting more information about our own expungement program. And finally, please be sure to visit Moho Justice, which is the reason I am presenting with you all today. So with that being said, Jay, are there any final questions out there that I have not yet addressed?
I do not believe so. Not that are in the chat right now, but y'all please offer if there's anything that you would like to just sneak in there before we wrap. Definitely have the ability to do that. I know many people might have had a very full day and we're kind of just using a little bit of brain to do whatever it is we're doing at the end of the day. But really, really grateful to have you all here. And I really hope you learned something. I think one of the main takeaways is that people need support in this process because it's very complicated. There are a lot of ways that folks are kind of, not necessarily set up to fail, but there's just all these loopholes, right? That you really would benefit from having a supportive lawyer, practitioner in your process with you. So I think that's one of my main takeaways from this is that we want to, I think, equip as many as many lawyers and as many organizations with this information. I think we're going to be in conversation with folks about CLEs and just all the different ways that we can get this information out. So just really grateful for you, Martin. I'm honored that you accepted the invitation to be a part of our 10 Days of Trans Demands campaign. And
Yes, and in addition to mentioning all of those great folks that you mentioned, Jay, even for just it at the individual level, having this information is so important just so we have even more reasons to press our various elected officials. Again, it blows my mind that when the expungement law, as it stands now, came out in January of 2018, that stealing was ineligible. There are so many people who were stealing records, and it's a charge that made no sense to be considered ineligible for expungement. So I'm glad that that change has came about, but far more changes needs to happen with the expungement law. And so as we arm more and more of our individual citizens with this information, we have more and more reasons to contact our elected officials to make sure our expungement law looks better so that more people who really need it can achieve expungement. Thank you for having me.
Absolutely. Thank you, Martin. If you actually wrap the screen share up, I can show folks a couple of things before you go, just so you know what exactly is coming up, because we do have 2 more events in the week of, really in the last few days of 10 Days of Trans Demands. And I wanted to also show you the report, which you can look up at mohojustice.com, and also take the Pleasure Pledge, which really speaks to making commitment to both trans folks, sex workers, and really yourself to do the work to kind of separate what you might have learned from what you might want to do in the future. So I'm just going to share that really quickly and let folks know. Whoops, share screen is being slow. So yeah, just want to encourage folks to have you join us at Club Red Light tomorrow, which is essentially on Instagram. If you've ever been to a club quarantine, it's like a DJ is there kind of giving you some energy. And we're going to have a few folks guest throughout to kind of talk about why they think this work is important. And so that's tomorrow night at 8. And then there's also an event. Ooh, sorry, my Zoom is acting up. Doesn't want me to show you. But there's one more event on Thursday. This is not necessarily the most important one per se, but it is pretty clutch because we want to make sure that folks know about it. It's similar to this one on YouTube, and it's with national guests as well as our local advocates. Co-leaders of the coalition will be there, hosted by our homegrown host, Maxi Glamour, drag artist and activist. And then I'll close by showing you the report here, which is just really a phenomenal piece of a phenomenal publication put together here by our digital organizer and our coalition, State of the Hustle, Sex Workers in Missouri, or Sex Workers Speak Out in the Show Me State. That is where we are. So just really grateful that is out, and want to, despite my computer being a little funky, want to make sure that you all see it and take it in at your convenience, because it is a really incredible publication that we really hope to use for many opportunities and engagements moving forward. So thank you all for coming tonight. I'm going to stop there and just really grateful for you, and hope you have a fantastic Monday night. Thank you for coming in. We'll do our best to share the slides and the information.